On April 4, 2023. While I was sitting in my kitchen drinking coffee, a man named Gary Tilden bought my house for $1. Not metaphorically. $1. On the courthouse steps in Kerrville, Texas, at a public auction I did not know I could attend until it was already over. By noon the deed had transferred. By 2 p.m. a man in a polo shirt knocked on my door and handed me a notice to vacate in 30 days.
Are you Renata? I have some papers for you.
I am Renata Voss. I am 64 years old. I taught 4th grade in Beaumont, Texas for 31 years. I drive a 2003 Camry with a crack in the dashboard that I keep meaning to fix. Nothing about me suggests I am the kind of person who wins against a developer with 3 attorneys and a 12-lawyer Houston firm on retainer. But I had something Gary Tilden did not know about. One sentence. Written in 1987 by a man named Earl Stubbs, on page 2 of a land deed that had been sitting in the Kerr County Records Office for 36 years. That sentence took everything he thought he owned and gave it back to me. This is the full story. How they did it, which laws they used, which laws they broke, and what you need to check in your own deed before someone runs the same play on you. My father Gerald Voss bought 4.3 acres of hill country land outside Kerrville in 1987 for $22,000 cash. He was a plumber. He kept every receipt in a cigar box. He built a small house on that land over 3 summers with his own hands. Concrete block foundation, metal roof, a porch facing west so you could watch the sun go down behind the Cedar Hills. He lived there from 1994 until he died in 2018. Left it to me in a will written on yellow legal paper in his own handwriting. 2 paragraphs. A probate court had no problem with it. I moved in after I retired in 2020. Planted a garden. Put a bird feeder outside the kitchen window. The kind of slow life you spend 30 years of early mornings earning the right to live. What I did not know was that while my father was building that house, a development company called Crestfield Properties was buying up the surrounding land. Through the early 2000s they built 214 homes on the acreage around us. They formed a homeowners association called the Ridgecrest Hills HOA. And when they recorded the HOA boundary in 2003, they drew it around my father's parcel too. He never signed anything. Never agreed to membership. Never paid dues because they never sent a bill. For 15 years nobody said a word. Then in March 2022, the first letter arrived. And the meter started running. What would you do if you came home to find someone had sold your house while you were drinking your morning coffee? Tell me in the comments. Tell me your state. Because what happened to me is not a one-off. It is a business model. And you need to know how it works. The letter was printed on heavy cream paper with a logo at the top. Ridgecrest Hills Homeowners Association. Property Management by Harlan Group LLC. It said I owed $4,800 in unpaid dues dating back to 2019. 3 years of assessments at $1,600 per year plus late fees. I had received 0 prior notices. Not one letter. Not one email. Not one knock on the door in the 2 years I had lived there. I called the number on the letterhead. A woman named Deborah answered. She sounded like she read from a script all day, which she probably did.
This notice says I'm delinquent. Let me pull up your account details. The map shows your property is highlighted. This falls under mandatory assessments.
She told me that under Texas Property Code Section 204, all properties within the recorded HOA boundary are subject to mandatory assessment. My property fell within the boundary. The obligation attached to the land, not the owner. That phrase. Attached to the land. I want you to understand what it means because it is the engine behind everything that happened next. In Texas, when an HOA records its covenants against a subdivision, those covenants become what lawyers call a covenant running with the land. That means they bind every future owner of every property within the boundary, automatically, regardless of whether you knew about them, signed them, or agreed to them. If you buy a house in a neighborhood with an HOA, you inherit the HOA's authority over your property as a condition of ownership. You do not get a vote on whether to accept it. It came with the house. What Crestfield had done was claim that my father's parcel, land that predated their entire development by 15 years, was subject to covenants he had never agreed to, simply because they drew a line around it on a map in 2003. I asked Deborah to send me the documents showing when I had been notified of this obligation when I inherited the property. She said she would look into it and call back. She never called back. I spoke to a local attorney named Carl. General practice. He looked at the letters and told me to just pay. Less than $10,000. Fighting it would cost more. I asked if they could actually take my house over HOA dues. He said technically yes, but they probably would not do that. Bad publicity. I paid $7,200 in June 2022 by money order. Kept the receipt. In August they sent another letter. I owed $3,400 more. Dues for 2022 plus attorney fees for processing my prior payment. Their attorney had charged me for reading my check. That is when I understood what this was. Not a billing dispute. A trap with a mechanism. Pay and the balance resets to a new amount. Do not pay and the balance grows. Either way, the meter runs. I stopped paying in September 2022. By December the balance was $11,400. By February 2023 it was $16,800. Attorney fees compounding on attorney fees. Late charges on late charges. In March 2023, the notice of foreclosure arrived. Here is what most people do not know about HOA foreclosure in Texas. The HOA does not need to go to court first. There is no judge who reviews whether the debt is legitimate before your home gets sold. Under Texas Property Code Section 209, an HOA with a recorded lien can conduct what is called a non-judicial foreclosure. They file documents. They post a required notice. They wait the statutory period. Then they hold an auction on the courthouse steps. Minimum bid is set by the HOA. They set it at $1. I found out later this is a documented tactic. Set the minimum bid low enough that no legitimate outside buyer will touch it because the opening price signals a title problem. The HOA or its connected parties win by default. No competition. $1. Gary Tilden was the president of the Ridgecrest Hills HOA board. Gary Tilden was also a managing partner at Crestfield Properties. The same man who ran the HOA that foreclosed on my property bought my property at the auction that HOA conducted. In most industries that is called a conflict of interest. In some jurisdictions it is called fraud. In Gary Tilden's world it was a regular Tuesday. I had 30 days to vacate a house my father built with his own hands. I sat on the porch the afternoon the notice to vacate arrived and looked at the bird feeder hung outside the kitchen window. A painted bunting was on it. Small bird, looks like someone colored it with a child's crayon set. My father used to say painted buntings only land where they feel safe. I gave myself 20 minutes to sit there. Then I went inside and started making calls. Carl, the general practice attorney, told me I was probably out of options. The foreclosure had been conducted correctly. Notices properly posted. Timeline met the statutory requirements. He said I might have a wrongful foreclosure claim if I could find a defect in the process, but he did not see one. His advice was to talk to the new owners about a leaseback arrangement. I thanked him and did not call him again. My daughter Rosa is a middle school science teacher in Austin. Not a lawyer. But she is the kind of person who does not accept a closed door as an answer. She spent 2 evenings searching property rights attorneys and legal aid resources across Central Texas. She found a name on a University of Texas Law alumni forum in a thread specifically about HOA abuse cases. Margaret Osei, 47 years old. Property rights attorney in San Antonio. She had spent the first 8 years of her career at a title insurance company, which meant she understood exactly how developers hid fraud inside paperwork because she had helped write that paperwork before she switched sides. Consultation fee was $400. I put it on a credit card. Margaret's office had floor-to-ceiling bookshelves and one window looking at a parking garage. She had reading glasses on a beaded chain and a habit of tapping her pen against her legal pad when she was thinking hard. She listened to everything without interrupting, making notes in handwriting so small and neat it looked like a font. When I finished, she said, "Show me your deed." I had brought the original. My father kept it in a fireproof box under his bed. I had not opened the box in 2 years. Margaret read page 1. Turned to page 2. She stopped. She did not say anything for about 30 seconds. Just sat there reading the same paragraph twice. Then she looked up. "Where did your father buy this land?" "From a man named Earl Stubbs," I said. "He had about 200 acres out there. Was selling parcels off through the 1980s. She turned the deed toward me and pointed to a clause in the second paragraph. The language was old-fashioned and dense, but this is what it said in plain terms. Earl Stubbs had written a restrictive covenant into the deed stating that the parcel was conveyed for residential and agricultural use only and could not be subjected to any homeowners association assessment, lien, or encumbrance imposed by any residential development on adjacent or surrounding land without the written consent of the grantor or the grantor's successors in interest. One sentence. 38 words in the original legal language. Earl Stubbs had built a wall around that parcel in 1987. No HOA could touch it without consent from him or whoever inherited his authority over the clause. His estate had never consented to anything. No one had ever asked them. Margaret set down her pen. "This covenant runs with the land," she said. "That means it binds every subsequent owner and every party who tries to claim jurisdiction over this parcel." When Crestfield drew their HOA boundary in 2003, either they did not find this clause, or they found it and ignored it. She paused. "Either way, every lien they placed on your property is void. The foreclosure is void. The deed transfer to Crestfield is void." She looked at me over her reading glasses. "This is the kind of case I have been waiting 6 years to file. Before I tell you what happened next, I need to stop for a moment because what Margaret explained to me in that office is something every property owner in America should understand. It saved my house. It could save yours. When you own property, your ownership rights are defined by a chain of documents going back to the original sale of that land. Every deed in that chain can contain restrictions, covenants, or clauses that travel forward through every future sale. Lawyers call them covenants running with the land. Most people read the first page of their deed. Sometimes the second. Almost nobody reads the full document, including every attached exhibit and referenced prior conveyance. The Earl Stubbs clause was on page 2 of a deed written in 1987. 36 years old. Buried in legal language dense enough that most people's eyes would slide right past it. Here is what I want you to do after you finish this video. Go to your county clerk's website or your county records office. Pull your deed. Read all of it. Look specifically for the words covenant, restriction, encumbrance, easement, and successors in interest. If you find language you do not understand, a real estate attorney can review a deed for a flat fee, usually between $150 and $400. That $400 Margaret charged me for a consultation was the best money I spent in 2023, including the credit card interest. Now, what Crestfield did not know, and what Margaret had already started suspecting, was that the Stubbs clause was not a surprise they had missed. She believed they had found it and proceeded anyway. To prove that, she needed their internal documents. And to get their internal documents, she needed to file suit first and use the discovery process to compel production. She filed the petition in Core County District Court on May 2, 2023. Causes of action: wrongful foreclosure, void lien, fraudulent misrepresentation, violation of the Texas Deceptive Trade Practices Act, breach of fiduciary duty by HOA board members acting in their personal financial interest against the homeowners they were supposed to represent. She also filed an emergency motion for a temporary restraining order blocking Crestfield from doing anything with my house while the case was pending. The judge signed the TRO the same afternoon. Gary Tilden had 48 hours notice that someone had found the clause. He did not take it quietly. Within a week, the Harlan Group sent code enforcement to my property 3 times in 5 days. Alleged overgrown vegetation. Alleged unpermitted structure on the back lot, which was my father's garden shed from 1996. Alleged improper drainage. 3 visits. 3 inspectors. Nothing actionable found on any of them. I documented every visit. Date, time, inspector name, outcome. Then the social media campaign started. A Facebook group called Ridgecrest Hills Community Watch posted a message about a delinquent former resident abusing the legal system to cloud the titles of all 214 homeowners in the subdivision. No name. Did not need one. My address was in the public foreclosure filing. My neighbor Pam, who had shared tomatoes with me the previous summer, stopped waving when she drove past. In June, Crestfield filed a countersuit. $34,000 in carrying costs since the foreclosure plus damages for harassment and interference with their legitimate business operations. A Houston firm with 12 attorneys. Margaret called it a slap filing. Strategic lawsuit against public participation. The tactic is straightforward. Bury the other side in legal costs until they cannot afford to continue. File enough motions, run up enough bills, and most people fold before trial. Texas has a law specifically designed to stop this. The Texas Citizens Participation Act allows defendants to file for early dismissal of meritless suits brought to intimidate, and it shifts attorney fees to the plaintiff if the motion succeeds. Margaret filed the motion the following week. Crestfield's response was a settlement offer. $12,000. Full release of all claims. Quit claim deed surrendering my interest in the property. For a house and 4.3 acres the county had appraised at $380,000. Margaret responded on my behalf with 4 words. See you in court. Discovery started in July 2023. This is the legal phase where both sides are required to produce documents, answer written questions under oath, and sit for depositions. Margaret described it to me once as the phase where people who believed they were untouchable discover they left a paper trail. She built a timeline. Crestfield Properties purchased the surrounding acreage in 1999. They recorded the HOA covenants in 2003. Those covenants included a boundary map that put my father's parcel inside the HOA zone. The covenants had to be based on a title search. A title search of all parcels within the proposed boundary, including ours, conducted by a company called Lone Star Abstract. Margaret subpoenaed those 2003 title search records from the county clerk's office. The search listed every deed restriction and covenant on every parcel within the HOA boundary. My father's 1987 deed was in that search. The Stubbs covenant clause was on page 4 of the report. Someone at Lone Star Abstract had flagged it with a yellow highlighter. They had seen it. They had read it. And the HOA covenants had been recorded anyway, with my father's land inside the boundary, without consent, in direct violation of a clause they had documented in their own records. Margaret then requested Crestfield's internal communications from 2002 and 2003. They produced 847 pages of emails. On page 312 was an email from Gary Tilden to the Lone Star Abstract account manager, dated November 2002. I am going to read you what it said because I want you to hear the specific words a man uses when he believes he will never be held accountable. The Voss parcel deed has a restrictive covenant that may complicate the HOA boundary. I need you to advise on whether we can proceed anyway given that the current owner is elderly and unlikely to pursue litigation. Respond to my personal email, not the Crestfield account. The current owner was my father. He was 71 years old in 2002. They had found the clause. They had read it. They had calculated that a 71-year-old plumber in the hill country was unlikely to hire a lawyer and fight them. So they proceeded. 20 years later, Gary Tilden made the same calculation about his daughter. I want to sit with that for a moment, because I think it is important. This was not a mistake. It was not an oversight. It was a deliberate decision made by a man who looked at my father's age and his bank account and decided the risk of getting caught was low enough to proceed. He was right about my father. My father died in 2018 without ever knowing any of this had happened. He was wrong about me. That email was the case. Everything else was just paperwork. Gary Tilden's deposition was August 14 in a glass-walled conference room on the 14th floor of a Denver building. Through the windows you could see the Texas Hill Country stretched out in the morning sun, which felt appropriate. Indifferent to what was about to happen inside. Tilden arrived in a charcoal suit with 2 attorneys. He did not look at me when he sat down. He had the practiced calm of a man who had been deposed before and knew how to produce words without producing information. Margaret started with background. Name, company, role. Standard. Then she slid the 2002 email across the table. I watched his face. He kept it composed. But his left hand, which had been flat on the table, slowly made a fist. Mr. Tilden, did you write this email? His lead attorney objected. Relevance. Margaret did not raise her voice or change her expression. Your Honor granted full discovery on all communications related to HOA boundary formation. This email is directly responsive. The objection was overruled in a subsequent motion. Tilden answered. He did not recall writing it. Margaret produced the metadata from Lone Star Abstract's email server records, which she had obtained through a separate subpoena. The email had been sent from Tilden's device. His IP address. His personal email account, exactly as the email itself directed. He had told the title company to use his personal email specifically to avoid the corporate discovery trail. He had not considered that the title company's server logs would retain the metadata regardless of which inbox received the message. He did not recall writing it. But the server remembered. By 11 a.m. he was sweating through his collar. By noon he had contradicted his deposition testimony 4 times. His attorneys requested 2 recesses. When Margaret finally said no further questions, Tilden stood, adjusted his jacket, and walked out without making eye contact with anyone in the room.
No further questions.
His lead attorney, named Dan Kelso, stayed behind. He looked at Margaret with something that read like professional respect across the table. Your client should settle, he said quietly. Your client should have considered that before targeting a retired schoolteacher because he thought she was too old to fight back, said Margaret. Name a number, he said. Margaret closed her notebook and said, Full title restoration. Every dollar paid in fraudulent dues returned. Damages for wrongful foreclosure, emotional distress, and loss of use. Gary Tilden removed from any fiduciary role in any Texas HOA permanently. The Harlan Group contract dissolved. Attorney fees paid by Crestfield. And a written apology from the board. Kelso gave a short, flat laugh. He will never agree to that. Then we go to trial, Margaret said. And I will bring Channel 9 San Antonio with me. 2 days later, Crestfield escalated in the direction I had been dreading. My son Daniel called at 6 p.m. He was 27, working as a line cook in Austin while finishing his culinary degree. His voice was wrong. Mom. A man came to the restaurant today. He described a man in a suit who had introduced himself as a private investigator. Asked Daniel's manager whether Daniel was reliable. Whether there had ever been any incidents. Whether his mother had ever displayed erratic or threatening behavior toward neighbors. Daniel's manager pulled him aside after and asked if there was something the restaurant needed to know. I wrote down the name from the business card Daniel read me. Thomas Brennan. Apex Investigations. I called Margaret. She answered on the first ring. I know. They hired a PI to dig for leverage. Going to your son's workplace is witness tampering. It is a felony. Forward me that card. I am filing an emergency motion in the morning. 3 days later I received an IRS audit notice. 3 years of returns flagged for irregularities reported by a third party. I was a retired W-2 employee. My taxes were 2 pages long. There were no irregularities. Margaret called when I forwarded it. They are panicking, she said. Rich people in legal trouble do this. They spend money on problems until the problems go away. They think everyone has a breaking point and they are searching for yours. They were not entirely wrong. I had been sleeping 4 hours a night. I had lost 8 pounds without trying. I was 64 years old and I was tired in a way I had not felt since my first year in the classroom when I used to sit in my car during lunch and cry because I did not know how to reach the kid in the 3rd row who came to school every day with the same hollow look and nothing in his backpack. I called Rosa that night. She listened to all of it. Then she said, Mom, you have already won the case. You just have not gotten to the end of it yet.
Mom, you have already won the case. You just have not gotten to the end of it yet.
I do not know why that helped. But it did. Trial was October 16, 2023. Kerr County District Court. Wood-paneled walls, ceiling fans that moved slowly and accomplished almost nothing, the smell of floor wax and recycled air. Margaret and I sat at the plaintiff's table. Tilden sat across from us with 3 attorneys and a paralegal who spent the morning arranging documents in color-coded folders. He was dressed like a man who expected to win. Cream shirt, no tie, the studied casualness of someone who has sat in enough courtrooms to know how to look relaxed. He did not look at me. This was a bench trial. No jury. Judge Carolyn Mather, late 50s, reading glasses on a lanyard, a reputation in Kerr County for zero patience with procedural games. Before Margaret opened, Crestfield's lead attorney filed a last-minute motion to exclude the 2002 email on the grounds that it had been obtained through a subpoena that exceeded the discovery scope. Judge Mather read the motion. Set it down. Looked over her glasses at Crestfield's table. Counsel, this email was produced by a third party in response to a properly issued subpoena. Your objection to its admissibility should have been raised during discovery, not on the morning of trial. Motion denied.
Counsel, this email was produced by a third party. It was in response to a subpoena. Objection should have been raised during trial. Motion denied.
Proceed. Margaret's opening statement took 9 minutes. She did not raise her voice once. She told the judge this case had one document at its center. A deed from 1987. A clause written by Earl Stubbs that said no HOA could attach assessments to this land without consent. She told the judge that Crestfield had known about that clause since 2002, had documented their knowledge in a written email, and had proceeded anyway because they calculated that the current owner was too old to fight them. They were right about the father, she said. They miscalculated the daughter. She called 4 witnesses. Sandra Pierce, a former Lone Star Abstract employee, testified that the Stubbs covenant had been flagged in the 2003 title search and that she had verbally advised Crestfield the clause was a problem requiring resolution before the HOA boundary could be recorded. She had not been asked to put that advice in writing. She understood now why. Rick Odom, a code enforcement officer with Kerr County, testified that Crestfield had filed nuisance complaints against neighboring landowners in 4 prior developments, always within 60 days of a legal dispute arising over a property boundary. He had inspected 6 Crestfield adjacent properties. He had found violations in 0 of them. A metadata expert from Austin testified that the 2002 email had been transmitted from Gary Tilden's personal device to his personal inbox and that the server log data was forensically intact and unaltered. Margaret called Gary Tilden as an adverse witness. He took the stand with the air of a man who had decided to say as little as possible and wait for it to be over. She asked him directly, in November 2002, "Did you know that the Voss parcel deed contained a restrictive covenant limiting HOA authority over that land?" His attorney objected. Asked and answered. Judge Mather said, "The witness will answer." Tilden, "I was aware there was some language in the deed that our title company was reviewing." Margaret slid the email across the witness stand. "Is this the email you sent to the Lone Star Abstract account manager about that language?" Tilden looked at it. He looked at his attorney. He looked back at the email. "I may have sent something like this." She had him on the stand for 40 minutes. By the end he had conceded that he knew about the covenant before recording the HOA boundary. He had conceded that the decision to proceed was his. He had conceded that he had directed communications to his personal email to keep them off the Crestfield corporate server. He had not conceded that any of it was fraud. His attorney had coached him well enough for that. It did not matter. Crestfield's defense argued that the Stubbs covenant was ambiguous. That the phrase successors in interest did not clearly cover the Stubbs estate. That my father's 15 years of non-participation in the HOA constituted a form of implied consent. Judge Mather interrupted the implied consent argument with a single question.
Counsel, if non-participation constitutes implied consent to HOA jurisdiction, then any property owner in Texas who has never signed an HOA agreement is potentially subject to retroactive HOA liability simply by existing as a neighbor to a subdivision. Is that the legal position you are asking this court to adopt?
Crestfield's attorney said it was more nuanced than that. The judge said she would issue her ruling within 72 hours. She issued it in 48. The ruling was 22 pages. I read it on the porch with a cup of coffee going cold in my hand. The Stubbs covenant was valid and enforceable as a matter of Texas property law. The HOA boundary as applied to the Voss parcel was void from the date of its 2003 recording. Every lien placed against the property was void. The April 2023 non-judicial foreclosure was void. The deed transfer to Crestfield Properties was void. I had been the legal owner of that property the entire time. $340,000 in damages awarded. Wrongful foreclosure, fraudulent misrepresentation, intentional infliction of emotional distress, and violation of the Texas Deceptive Trade Practices Act. Because of the 2002 email, the violation was classified as knowing and intentional. That triggered the DTPA's treble damages provision. The fraudulent dues scheme, the attorney fees Harlan Group had charged me for processing my own payments, the compounding late charges, all of it was subject to multiplication. Margaret's fees were paid by Crestfield under the court order. The case was referred to the Texas Attorney General's Consumer Protection Division and the U.S. Attorney's Office for the Western District of Texas. Gary Tilden resigned from the HOA board the day the ruling was published. I sat on the porch until the sun went behind the Cedar Hills. The painted bunting came back to the feeder at dusk. I watched it for a long time. The federal investigation moved slowly, the way federal things do. Margaret told me not to expect anything fast. But in March 2024, the U.S. Attorney's Office indicted Gary Tilden on 3 counts of wire fraud and 1 count of conspiracy to commit real estate fraud. The indictment cited the 2002 email, the Lone Star abstract payment records, and 2 other properties in Crestfield developments where the same scheme had been run against elderly landowners. Both of those landowners had settled. Both of them were contacted by investigators as potential witnesses. One of them, a 79-year-old man named Harold Greer, called me in April. He had heard about my case through a property rights advocacy group in Austin. He said he had paid $23,000 in HOA fees he never owed before settling for $40,000 and a confidentiality agreement. The confidentiality agreement did not survive the federal subpoena. He cried a little on the phone.
I just can't thank you enough. Never thought this day would come.
I was not expecting it. I did not know what to say except that I was glad he called. I am not a folk hero. I want to be clear about that. I am a retired 4th grade teacher who had the specific luck of a father who bought land from a careful man named Earl Stubbs who knew enough to write 1 protective sentence into a deed in 1987. Most people do not have that sentence. That is the part that keeps me up at night. The families in the Ridgecrest Hills subdivision, the 214 homeowners who had nothing to do with any of this, had their HOA restructured by a court-appointed administrator. Their dues were audited. The Harlan Group had been overcharging them too, skimming management fees above what the contract allowed. They got refunds averaging $1,800 per household. Small amount. It mattered to people. My father's garden shed is still standing on the back of the lot. I repainted it last spring. Put a new latch on the door. His old tools are still inside, hanging on the pegboard in the order he always kept them, largest to smallest, left to right. The painted bunting comes back every March. I have no scientific explanation for why it returns to exactly the same feeder. My father would have said some things know where home is. I kept 5 things from this whole experience that I think are worth passing on. First, read your deed. Not just the first page. All of it. Restrictions, covenants, easements. If you inherited land or bought property without a thorough title search, pull the deed from your county records office. It costs nothing to look. Second, in Texas, and in many other states, an HOA can foreclose on your home without a court order for unpaid assessments. This is not a threat buried in fine print. It is a statutory right they have. Know whether your state allows it. Third, a lien on your property is not just a debt. It is a claim that travels with the land through every sale. Deal with it before it compounds. Fourth, demand proof of authority. If an HOA claims jurisdiction over your property, ask them to show you the recorded documents proving your land is within their boundary and that you or your predecessor in title agreed to be bound. They are required to have those documents. If they cannot produce them, that is your starting point. Fifth, the law has quiet title actions for exactly this situation. A quiet title lawsuit asks a court to officially confirm who owns what. It is slower and more expensive than most people want, but it is the mechanism that exists when someone is claiming rights over your property that they cannot legally prove. I sit on my porch most evenings now. The cedar hills are going orange and gold in October. The creek is running low after a dry summer, but it is still running. My father built this place with his own hands over 3 summers. He refused to let anyone take his trees. He left me one instruction. On a sheet of yellow legal paper tucked inside a deed that had one very important sentence on page 2. He wrote, "This land is yours. Keep it." I kept it. If this story meant something to you, share it. Not for me. Share it because there is someone in your life who owns property and has never read their deed and does not know what an HOA can do in your state. And if you have been through something like this, put it in the comments. Tell me where you are. Tell me what happened. I read every one. Next week, I found out my county had been illegally assessing my property taxes based on a survey error. The county owed me 11 years of overpayments. They did not want to give it back. Subscribe. You are going to want to see how that ended. Keep your receipts. Keep your deeds. And read every word on every page of everything you sign. Every word. And if you liked my story, do leave a like on this video, and leave your thoughts in the comment. Subscribe to this channel for more interesting HOA stories.